Thank you, Peter. That was fascinating, and it opens up some really nice moments for us to talk about rights to science, but also rights to contribute, rights to take part in decision making. So thank you for bringing that up towards the end. So I'd now like for our last speaker to introduce Rumiana Yotova, who is a legal scholar from the University of Cambridge.
Thank you very much. Sorry, there is always the PowerPoint moment, but we're nearly there.
There we go.
Okay. So I believe I'm one of the very few lawyers in the room. I am based in Cambridge, and the reason I was invited here today is that a year and a half ago, Professor Bartek Knoppers approached me, and we did a project together on the right to benefit from science. And we approached that right from the perspective of public international law. This is the body of law that applies between states on the international plane, but it also regulates the relations between the state and the individuals on the territory of that state. So my mission today is to talk more about this right. We've heard multiple references to it yesterday and today, but I really want to delve into its legal content and more specifically, its implications about sharing genomic data. A bit of a disclaimer, I'm a public international lawyer, so please don't ask me specific questions on the GDPR, privacy, or IP law, because I will probably not be able to answer them. So I will begin by talking generally about the right to benefit from science. Then I will focus on its implications for our mission here today. And as we heard, this right informs the mission of the Global Alliance. And the work of the Global Alliance is very important in activating and promoting awareness of the right to science. And finally, I will draw a few tentative conclusions on how I see the way forward, moving on towards a more international regulatory framework to help align different domestic approaches. So, on the international plane, the right was first formulated in the Universal Declaration on Human Rights. If you look at the wording of the Declaration, the right is very much formulated like a freedom. Everyone has the right freely to share in scientific advancement. But what does that mean for the state? It doesn't clearly indicate any positive obligation on the regulators to enable access to the benefits from science. And this is why I'm going to focus more on the right as set out in the International Covenant on Economic, Social and Cultural Rights. Now, the Covenant is actually a binding international treaty. It has 169 states parties, which have agreed to it. And in this treaty, the states have recognized that everyone has the right to enjoy the benefits of scientific progress and its applications. And I think it's interesting to note that the right to benefit from science usually comes in the same provision as cultural rights, and always together with the right of authors of scientific works to protection of their moral and material interests. And what is really helpful is that the Covenant actually tells us what specific steps states ought to take to enable the right to benefit from science. In particular, they need to enable the conservation, the development, and the diffusion of science. And here we're really concerned with this aspect of the diffusion of science. Interestingly, the right also includes scientific freedom. The freedom of research is part of the right to benefit from science. And finally, the last paragraph contains an encouragement to states to share science across borders. But if you look at the actual formulation of paragraph 4, you will see that this is not a positive international obligation. It is a recognition that we should try to do it as much as possible, but without actually having to do so under law. So a few general words about the International Covenant. It is part of the International Bill of Rights. We have two covenants, and this is one of them. It is signed and ratified by most states of the international community, with some notable exceptions like the US. And it contains the so-called second generation of human rights, which means that they're not automatically available as soon as the state signs the covenant, unfortunately, but because they're so closely linked with the economic resources and the state of development of every state, they're subject to the progressive realization. And the emphasis really is on equality of access and non-discrimination when it comes to the right to benefit from science. Another thing about human rights in general is that they are binding vertically. So they're binding upon the state, and it is for the state to ensure that the persons, individuals and corporations within its jurisdiction have and can enjoy the human right. What human rights do not do is regulate relations horizontally between individuals or individuals and corporations. So in practice, this means that the right to benefit from science would be binding upon the state, but also upon its, say, public healthcare institutions or research institutes, but it would not be binding upon corporations working in the same field, unless the state has legislated to make it so. Now, it is true that the right to benefit from science is underdeveloped. So it is one of the very few rights in the International Covenant that doesn't have a general comment by the United Nations yet. We're hoping and expecting to get one next year. It has been compared by academics to the Sleeping Beauty of human rights. So we definitely need more initiatives like the Global Alliance to raise awareness and promote and awaken the right to benefit from science. So a bit about our research and how we went about to establish the content of the right. Normally, the golden rule of treaty interpretation is to start with the ordinary meaning of the terms. Now, this all sounds wonderful, but if you look at the way the right is formulated, the terms are so broad and general that it is very difficult to get a clear idea of what it means that we each have the right to benefit from science. The second tool of treaty interpretation is to look at the intentions of the drafters. What were they intending to regulate when they drafted the instrument over 40 years ago? And finally, we looked at the subsequent practice of states. What do states understand the right to benefit to science to mean, and how do they implement it in practice, in domestic policies and legislation? So, looking at the preparatory works, we were pleasantly surprised to see that even though the covenant was negotiated during the Cold War period, and there was quite a stark opposition between developed and developing states, they seem to be on the same page in agreeing that the right to benefit from scientific progress means disseminating basic scientific knowledge and sharing the results from scientific research. And indeed, the statements by the US and Russian representatives were to that effect. So, looking at the subsequent practice of states and what they are actually doing to give effect to the right, fortunately, states are obliged to issue periodic reports under the Covenant on the specific measures they have taken to give effect to the human rights. So we used those reports in our research. And we also used state responses to a questionnaire in the field of the right to enjoy the benefit from science. So what we discovered is that 90% of the states who reported back to the United Nations under the Covenant specified that they actually took measures to give effect to the right. And this is really strong evidence of the general acceptance and recognition by states that there is a human right to benefit from science and that they have to take positive action to enable it. So what did states do? Around half of them adopted legislative measures. Notably, most of these are constitutional measures, which shows the high importance that states attach to the right to benefit from science. The other trend we noticed is that a growing number of both developed and developing states recognize an obligation to give access to everyone to scientific information and an obligation to disseminate science. Since the 2000s, there has been also a growing uptake on open access. There was a Berlin Declaration, which was non-governmental, but increasingly states have got on board with that requirement and now require that state-funded research has to be published open access. Now, there is some difference as to the understanding of giving access to science, and some states say access should be entirely free to everyone. Other states are a bit more cautious in their approach in requiring access on an equitable basis, meaning enabling those who cannot afford it to be able to access it. Now, turning to the most relevant part for our purposes today, we were pleasantly surprised to discover that actually the most commonly reported measure to give effect to the right by over 55% of the states' parties were different types of measure promoting the dissemination of science. And here I've given a few examples of concrete measures that were mentioned in the state reports, which included setting up state document repositories, data banks, databases, obliging national science institutes to publish their research results and data, imposing an open access requirement, but even subsidizing researchers to publish their research in an open access format. A number of states provide for a right to freedom of scientific information specifically, and there are more and more attempts to establish data exchange scientific networks between different research institutions. So, what do we think are the implications of the right to benefit from science for big genomic data? We think that the right to benefit from science is essentially a right to access scientific information and data. We think that state practice supports this to be the core normative content of the right, and that would include genomic data. It would also include the protection of freedom of scientific research. There are also some obligations that flow from the right, including an obligation on researchers to exercise the right in a manner respectful of other human rights, and that would include the right to privacy and to prior informed consent, and also obligation on the state to protect people from the negative effects of science. And finally, the right encourages international or transnational data sharing, even though it doesn't mandate it. However, a word of caution, adopting a human rights approach to big genetic data has its limitations. As I said, it only directly binds the state with its institutions. In case there is a conflict of interests between the interests of the individual and the broader interests of the public or the international community, under human rights law, the interests of the individual always prevail. And finally, the right doesn't quite mandate an international data sharing approach. There are different ways to get around these limitations. One could impose sharing obligations on private actors under domestic law. There are codes of corporate social responsibilities. Again, corporations can be encouraged to make use of those. And indeed, states can foster public-private partnerships with special requirements for data sharing. And here I've given a good example from the EU Horizon 2020 program, which highlights how they promote data sharing, which is through requiring that all funded projects have to be published. So, a few words on the way forward. There were a few voices yesterday who said that we need an international agreement, and I fully agree with that. I think we need an international debate and hopefully an agreement on a governance framework for responsible genomic data sharing. There are different platforms available. The UN specialized agency that deals with science and education is UNESCO. They've done quite a lot of work and soft law instruments on genomic data and the human genome. I think it might be wise to complement the human rights framework with a global public goods framework, and indeed a number of institutions have called for that, because a global public goods framework would encourage international sharing of data and also guard against overly privatizing knowledge. So thank you very much for your attention, and I look forward to your questions.